Welcome to an oral argument session of the 5th District Court of Appeal. My name is Jay Cohn. I'll be presiding this morning. I'm sitting in for Judge Harris, who's under the weather, but I have read all the briefs and reviewed the record in this case, so I'm ready to go forward on it. On the panel today as well, we've got Judge Mary Alice Nardella from Orange County. And then we are privileged today to have as an associate judge, Judge Melissa Soto from Seminole County, joining us this morning. As I said, this is being recorded on YouTube. Our ratings of late have been sagging, but we're hoping that this oral argument will just take us to another level and get those ratings back up where they belong. But just be aware of the fact that we are recording the session this morning. The first case that we have this morning is Jose Alejandro Perez Flores versus State of Florida, case number 20-1138. Mr. Magaro, I do a default 5-minute rebuttal, but that's negotiable. Anything that you would like, I'll be glad to accommodate. Just let us know when you begin your argument. Each side will have 20 minutes in total for their argument. There is no penalty if you don't use all of the time. So we are ready to proceed. Mr. Magaro.
Thank you. Good morning. May it please the court and counsel. My name is Patrick Michael Magaro, and with the court's permission, I'd like to reserve 5 minutes for rebuttal. That being said, as a young defense attorney, which seems like a very long time ago, I learned and I was trained very early on that if there is a process available to you in the law that will secure your client's best result, you need to avail yourself of that opportunity, or in the alternative, you better have a very good reason why you didn't, because someday, if you don't do that and you don't have a very good reason, you may be called to task. And that's especially so in a case where your client is insisting that he is innocent or he or she is innocent, and is demanding nothing less than the attorney's best efforts in securing some sort of disposition that will achieve that goal of clearing the client's name. Now, in this particular case, we have a very, very, very close case involving self-defense, and it is a classic he said, she said type scenario. There is a fight. There is a...
We're aware of the facts of the case. Let's talk about some of the legal issues that you've raised in your brief. So let's begin with the allegation that a plea offer had not been conveyed by Mr. Yeager. I think if I have the timeline correct, by the time of the post-conviction hearing, Mr. Yeager was deceased. Is that correct?
That is correct. That is correct.
But there was a your claim is that your client wasn't given the 4-year, wasn't informed of a 4-year plea offer, but we do have a transcript of a hearing at which time Mr. Yeager either withdrew or was removed as counsel from the case, where it was very clearly articulated that there had been a 4-year offer extended, and that was done in the presence of your client. And so I'm struggling to see how you can successfully bring forward an allegation that he wasn't informed of that when the record seems clear that he was.
Well, at first blush, I would agree with the court, but when you scratch beneath the surface, you see that there's a lot more to it than simply that, which is what the state wants the court to accept. But what we have here is a person without, well, first we have a non-English speaking client who legitimately does not understand the English language, requires an interpreter to not only translate the court proceedings, but also, as Mr. Yeager said during that September 2nd, 2014 hearing, that he needed an interpreter in the office just to converse with the client.
All right, but there was an interpreter at that hearing, at which time Yeager's representation ceased.
That's correct. And when we look back, he said, Mr. Yeager says something along the lines of, I had brought him into my office and he did not like the interpreter that I had there, but we needed, and basically saying we need an interpreter just to talk. There is a mention of a 4-year plea offer. However, what we know is this. As of September 2nd, 2014, which was the date that Mr. Yeager went on the record and talked about that, the plea offer had long since expired. There was never any discussion on the record that he discussed the plea offer with my client prior to its expiration, and what exactly that the discussions were. And then also, when you look at the transcript of the hearing, he says plea offers, multiple, plural. We don't know exactly which offers were extended, if any, and how they were communicated to the defendant. And we have a defendant without an extensive knowledge of the criminal justice system. I believe this is first or second contact. It's his first felony, that's for sure. And with a non-English speaking client, there's simply not enough on the record to make that mental leap that, oh, well, he wasn't fully informed prior to the expiration of this plea offer, and he made the decision not to accept that offer. That
the record appears that your client, kept asking Yeager, I want, before I make the decision, I want to have, the depositions, and then no, well, even though the deposition had, I guess there was a CD of it with a translation, with a Spanish translation. Well, that wasn't good enough. Then he wanted a transcription of the of the depositions, and all of this is occurring right before trial. In fact, the motion, Yeager's withdrawal, I think, was like the day before trial. So it sounds like there's a little bit of gamesmanship going on here.
Well, I would respectfully disagree, and I explain why. If I were, I try to think, put myself in a client's shoes. If I were making a decision whether to put myself in prison or not, I would myself want to know exactly what was said by witnesses at a deposition before I weigh the pros and cons of going to trial or rejecting what is obviously a favorable plea offer. I would want to know what my chances are, and I think it's.
Yes, you say the 4 years. You think that was a favorable plea offer?
In light of what he ultimately received, well, absolutely.
All right, 5 years would have been a reasonable plea offer as well, wouldn't it have been?
5 years, but it was not just 5 years. 5 years plus 10 years of probation. Which
okay, but in terms of going to prison, which is what most people really care about, the 5 years would have been a reasonable offer too.
I agree, but every day in jail certainly counts. And when when it's a lawyer who's trying to communicate with a client who doesn't understand the system, doesn't understand English, I myself as an attorney would want my client to be in a position where he's seen all of the discovery, he's read it all himself, I've reviewed it with him.
All right, but the point I'm making is that down the line, after Yeager is removed and after we've gone through another couple lawyers, your client turns down a 5-year plea offer, and so it's just hard to make that leap of faith that you would like us to make, that he turned down the 5-year plea offer, but boy, if he had only known about that 4-year plea offer, he would have jumped on it.
Well, it's when you consider it's 5 years plus 10 years of probation, and I know from experience, probation, unfortunately or fortunately, however you want to view it, many clients see that as a potential trap, because 10 years is a long time to go without any sort of hiccup in the road, and that 10 years of probation can turn into a 10-year sentence or even worse. When you weigh that against 4 years, you're done. You owe the state nothing once you're released, as opposed to 5 years plus 10 years of probation, 10 years of opportunity to put yourself back into prison. To me, that it's not just the prison time. And I think Mr. Perez-Flores did testify to that effect at the 3850 hearing. That factored very heavily in his mind. 10 years is way too much time to put myself in a position where I could get violated for this or that and end up back in prison and end up doing a lot more than just 5 years. So I understand both points of view, but on the practical side, the court is 100% correct that the primary concern for most people is prison or no prison. But then when you get down to, well, it's prison plus probation or prison without probation, I've certainly been in the position many times over the years where clients have said, you know what, I'd rather do a relatively shorter or even sometimes a little bit longer prison sentence than have to worry about probation and all that entails at the back end of that. So,
well, as long as we're going to interject our personal impressions into this, having sat on a criminal court bench over 18 years at various times, I've seen people that had no chance in the world of making probation that took the offers because they were just convinced that they could do it. Right?
100%. And then, they meet with predictable results.
Usually.
I agree. Not everybody is, let's say, as well as mentally equipped to make that decision as others. But in any event, that is exactly what Mr. Perez-Flores testified in this case. He said there was a huge difference in his mind of a 5-year plus 10-year probationary sentence as opposed to a 4-year and being done with, any obligations to the court of the state of Florida at the end of that. And he said he would have accepted that 4-year offer. But again, we have nothing in the record that says that Mr. Yeager explained that to him prior to the expiration of the plea. And I think that is the critical difference here that makes the difference. Mr. Perez-Flores said he did not, and there really wasn't any evidence to contradict that.
Let's talk a little bit about the stand your ground argument that you make. Back at the time of your client's case, the burden was on your client, Mr. Perez-Flores, to establish the stand your ground factors. 3 lawyers looked at it, and 3 lawyers made a determination that it wouldn't be successful. And how would you explain then how you'd have to establish as part of the Strickland prong prejudice? He's convicted by a jury of these offenses, and that's a beyond a reasonable doubt standard. How can you establish prejudice on the failure to have requested a stand your ground hearing?
Certainly. And first, I would just like to point out, I don't think it was 3 lawyers looked at it and decided it wouldn't be successful. We never heard from the 2 first lawyers as to what their reasons were or were not for pursuing this. And the only lawyer that we did hear from was Mr. Donati, that testified at the hearing. And his reason for not pursuing it was he thought that the time to make the motion had expired. And that was his explanation as to why he didn't pursue that, because in his words, too much water had flowed under the bridge at that point. The case was too far along, and he thought that the time had expired. Nevertheless, we know from the result of the case is that, number one, self-defense was the defense from day one. From the time that my client and his brother were arrested, I believe the initial statements to law enforcement were that they were acting in self-defense. When you have a defendant who's telling his lawyer, as is on the record, I'm innocent, I didn't do anything wrong, that is an assertion of self-defense, and that is exactly what was pursued at trial. And it was at least partially successful because my client was convicted of some lesser included offenses, and the brother, Christian Flores, was only convicted of a misdemeanor as a lesser included offense. So the jury at least credited that defense in part. Now, when we turn to the prejudice prong, we know that even in 2012, the stand your ground is not just a defense at trial, it's offering complete immunity from prosecution. And there was a process. The burden was different, but that doesn't change the inquiry or the focus of the inquiry. The inquiry is, was the defendant was the defendant acting in self-defense, yes or no? If yes, then the court has no reason or no other option but to dismiss and afford the defendant immunity from prosecution. If not, then the case simply goes to trial and a jury then decides the question of self-defense. So the burden itself, which is what the court below relied upon, who had the burden, who didn't, at the end of the day, it doesn't really matter. If self-defense is established, and in this case, by preponderance, because the burden was lower than it is now on the defendant, then the defense can claim that. And the prejudice is he's never in the position of being in jeopardy of losing life or limb. So that right there is the prejudice. And the question turns to, why not move for stand your ground immunity? No one has offered a valid explanation for that. And if you were to ask me, of course, I would say there is no valid explanation for failing to move that when you know as a lawyer from day one that there is a self-defense claim, there's weapons used, there's competing witness narratives as to what happened, and especially when this is a closed case, and it comes down to a credibility match, you should, as a defense lawyer, be pursuing that. And this court has said, there's been one case at least that has said that the failure to pursue stand your ground immunity can constitute an effective assistance of counsel. But when we compare that to other cases where this court and a number of other courts have said failure to pursue, for example, suppression or a dispositive trial defense can constitute an effective assistance of counsel. And even this court has said failing to pursue a suppression motion, a valid suppression motion that's dispositive, even survives the entry of a guilty plea and can be used later to challenge the voluntariness of a guilty plea. That tells you how strong and how much stock then a court should put into a lawyer using a process available to them by the law in order to take their client out of jeopardy completely, be it suppression, be it stand your ground, or be it some other, maybe even a pretrial motion to dismiss.
Well, but it seems, I don't think that at least from my perspective, I'm not challenging your assertion that the failure to bring a stand your ground motion could, under certain circumstances, constitute ineffective assistance of counsel. But it's the second prong of it that I struggle with.
Of course, and I think that the prejudice, the proof is in the pudding, so to speak. If we look at how this,
that's exactly what the state's going to say.
And if we look at how it now, if this had been a guilty verdict down the line as charged as to both defendants, I would say I would have a much harder time.
Yeah, but the jury had self-defense and could have walked your client and did not on the self-defense, on that defense. They
could have. That's absolutely correct. But when you see a verdict, a Nick's verdict or a verdict of lesser charges, conviction on lesser includeds, in my mind, that shows that the jury is at least factoring that in somewhat.
You're into your rebuttal time. I know we haven't hit the interpretation questions, but would you like to keep going or reserve that time?
I'll keep going. And regarding the interpretation, what we have here is basically unchallenged testimony as to that there were problems. And if we look at the trial record, even the trial lawyer said, and it's in the trial record and it's in the 3850 record as well, that at one point there was some issue with my client's mother testifying and not understanding the translator. He brought it to the court's attention. And, when we look at his answer at the 3850 hearing, when he was asked, what would you have done if the translation was inaccurate? What steps would you have taken? He says, honestly, I'm not sure what I would have done. So then to make that leap.
But did your client or his brother raise that issue to counsel during the course of the trial?
They testified that they did. And the attorney testified he didn't remember one way or another whether they did or didn't. And when we take that with, he doesn't know what he would have done.
I thought he testified that he didn't recall them.
He said, I don't recall.
But he testified further that if he would have taken the same action if he'd been told that he took when he was aware of the mother's testimony, not understanding the question. Isn't that correct?
He said something along the lines later in the same answer, but initially his initial reaction is, I don't know what I would have done. And he says, now that I'm looking back, and I do remember there was some issue where the witness was saying that she didn't understand the translator. And I asked, and my interpreter said to ask the same question using different phraseology. I imagine I might have done something like that. I imagine I would have pointed it out, but, I guess I would have done that doesn't amount to, I definitely, number one, the defendant never told me. And number two, had he told me, I would have immediately corrected that. That is a bridge too far, in my humble opinion. So when you look at side by side, the differences in the translation, they're relatively significant when you take that with the fact that this is a closed case and every detail matters. Who picked up the stick first? Who picked up the machete first? Where they got these weapons from? Was it the defendant's car? Was it the complaining witness's car? All of that comes together, and where the rubber meets the road is always in the summation. And that is exactly what the state used to pave the road, so to speak, and argue to the jury, these people are incredible. You should not credit their testimony. Credit my witnesses, not the defense witnesses, because this is what they said. And if what they said is wrong and the state is relying upon that, that's where the prejudice is. Now, I know I've probably used up all of my time. I see that I have. If the court has any further questions, I'm happy to answer them, or I'm happy to rely on the record as it is.
All right. Thank you, Mr. McGarrett.
May it please the court. Good morning, Kelly Nealon on behalf of the state of Florida. As to the plea deal issue, I think the issue is, did counsel tell him about the plea deal? And I think that the transcript of that hearing reflects that counsel clearly did. It almost looks like counsel begged him to take that plea. And that was how the whole attorney-client relationship broke down in this case, because he just was not following his attorney's advice. As to the translation issue, I think that's just inherently credible. Now, if counsel had brought in the audio tapes from the trial and had someone testify that, yes, this is exactly what was said, then they may have at least made an effort to meet their burden of proving this. But having testimony from two witnesses who needed a translator because they couldn't understand the English language apparently, then come like 5 years after trial and say, well, no, this is what really happened and this is what the witness said. I mean, that's just an inherently incredible claim. And that's essentially what the trial court found even before he had a hearing, and then said, but I'm still going to have a hearing just to ensure that this is what actually happened. And that kind of dovetails into the self-defense claim too, because his self-defense claim is based mostly on this corrected testimony of these witnesses, that there's no evidence whatsoever that there was any mistranslations in this case. So if there are no questions from the court, I will rely on my brief for the any remaining issues and ask this court to affirm the order of the trial court.
All right. Thank you, Ms. Needham. All right. Thank you both for your arguments, and we will